everyone, good afternoon. My name is Pitagatis Paltani, and I would like to present my research entitled The Administrative Court Conceptual Reform with a Contemporary Administrative Law Perspective. The author is me and Ajeng Rahayu. So we start from the explanation from the background of the administrative court in Indonesia. So the introduction, definition, and purpose. After administrative courts are specialized courts that adjudicate disputes between private citizens or entities and public authorities to ensure that government actions are lawful, fair, and adhere to principles of good governance. But in reality, Indonesia doesn't adopt a dual jurisdiction judicial system as the case in some countries with civil law or continental European legal system such as France. So the role is uh, they act as a crucial check on executive power, protecting individual rights against potential state threats. So, the Indonesian judicial structure tends towards the combination of the civil law and common law principles known as the unity of jurisdiction system with the existence of an administrative court but still subordinate to Supreme Court. So, therefore, it's important to examine in more depth the urgency of establishing the administrative court, not only as a conceptual reform but also to prevent the number of cases before the Supreme Court from exceeding uh, those of lower courts. So, in here, before we continue to the research questions, there are several functions of administrative courts. The first one is reviewing the legality of administrative decisions, act, and regulation, providing an impartial venue to resolve conflicts between citizens and the state. Number three, holding public officials and agencies accountable for their actions. And number four, ordering corrective measures such as annulling unlawful decisions, awarding damage, or compelling an agency to act. So there are two questions. Include the first one is what is the structure and status of the judicial system in Indonesia, and the second one is what is the urgency of establishing an administrative court as a conceptual reform from a contemporary administrative law perspective. So we next to the method. This research was conducted using a normative juridical legal approach that examines legal principles, legislation, conceptual approach, and uh, comparative studies. So before we go to the results, I want to explain about the differences about the jurisdiction system between the administrative court in Indonesia and France. Because if we take a look in French jurisdiction system, there is Considenta, which is in top hierarchy of judicial system that can, but in Indonesia doesn't have it. So Indonesia and France both are civil law countries, but have a distinct approach to administrative justice. So if we look into the system overview, The Indonesian judicial system has the unified court system under the Supreme Court. In Indonesia language, it is known as Mahkamah Agung. And in Indonesia, it has administrative courts, which is in Indonesian language known as Peradilan Tata Usaha Negara. It's the specialized branch within uh, this general judiciary structure. So, uh, both of in Indonesia or France, both review and decide disputes between the individual versus government body or disputes from official. So the roles in here is trying to ensuring government's actions comply with the law and general principles of good administration, and to protecting citizens' rights from unlawful administrative decision. So if we that is the system overview in Indonesia. But if we take a look on system overview in France operates a dual court system with separate judicial and administrative court. It is established by Napoleon in 1799. It evolved from King's Council as the Conseil de Rule. So uh, there is a Considenta that serves two primary functions. The first one is Supreme Administrative Court as the top hierarchy and as the highest administration jurisdiction, acting as the final arbiter for cases involving the executive power, local authorities, and public bodies, and as a government advisor. And the jurisdiction is to handle disputes related to public freedoms, uh, taxations, uh, public contracts, civil service, and environmental law, and etc. So I want to pull the line between the difference with the system overview in Indonesia and France. The system structure is unified judiciary part of Supreme Courts, meanwhile in France is in dual court system. So the hierarchy is in Indonesia subject to Supreme Court, meanwhile in France it is as the independent supreme body with its own hierarchy, which is administrative court, appel, and administrative tribunals. So Considenta is in the top hierarchy, and I think Indonesia will become a better jurisdiction system if we take a look and absorb from the judiciary system from France. So even it both shared principle, the same shared principles, like both systems are within the civil law legal traditions. Uh, and then the both systems aims to control uh, how to control administrative actions and accountability in a good governance and about the protections of rights. So both serve as a mechanism, as we know, for citizens to challenge government decisions which violate their rights. So this research is to try on the hierarchy of France to be observed in Indonesia. So the administrative court is the top hierarchy, the same as the Supreme Court in Indonesia. So we can go to the conclusion as the preliminary results include the first one is Indonesia has adopted the dual jurisdiction system as in France, where the general courts are subordinate to Supreme Court and the state administrative court are subordinate to the Considenta. The case are resolved by state administrative court, continue to be resolved by Supreme Court, the highest court. And then the second, the preliminary results, is the importance of establishing a separate administrative court so that the PTUN as the first hierarchy of jurisdiction administrative jurisdiction system in Indonesia can be resolved directly by the administrative court, reducing the backlog of cases, and as the Supreme Court and acting as supervisory functions for government agency. So this is part of judicial reform as an effort to realize uh, the function of judicial power independently and effectively, and to ensure the legal certainty and justice in accordance with the sociological jurisprudence theory pioneered by Roscoe, which states that judges are not only mouthpiece of the law but also the agents of social change. So, um, I think that's all from me. I hope this research has provided valuable insights, and thank you very much. Assalamualaikum warahmatullahi wabarakatuh.